Can you guys see the slides?
Hi, everybody. We're just going to wait a couple more minutes until 1 o'clock before we get started. All right, everyone, it's 1 o'clock, so we'll get started now. Hello and welcome to the Landlord Self-Help Center's Landlord Lunch and Learn session. My name is Catherine. I am a licensed paralegal and community legal worker with the Landlord Self-Help Center. My colleague Tanya is also going to be presenting with me today. The Landlord Self-Help Center is a community legal clinic funded by Legal Aid Ontario. It was founded in 1975 and incorporated in 1977. We have a province-wide mandate to support the small-scale landlord community, with approximately 80% of our resources being dedicated to client services. This Landlord Lunch and Learn session is the first of this year's series and will focus on eviction for non-payment of rent. This presentation will be made available for replay on our website and on our YouTube channel. Our past presentations are already on there for your reference. At the end of this presentation, we'll be having a Q&A session. Our viewers are encouraged to ask questions that pertain to the topic of non-payment of rent only. Please note that the information offered in this presentation is intended as general advice and is not legal advice. For our land acknowledgement. At Landlord Self-Help Center, we acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We acknowledge that Toronto is covered by Treaty 13 from the Mississaugas of the Credit and the William Treaties, signed by multiple Mississauga and Chippewa bands. As a community clinic funded by Legal Aid Ontario with a province-wide mandate, we acknowledge that there are 46 treaties and other agreements that cover the territory now called Ontario, and we make this acknowledgement in support of the necessary work of reconciliation. The Residential Tenancies Act. The Residential Tenancies Act was created in 2006 and is the Ontario legislation that governs most residential tenancies and matters related to renting in Ontario. The Residential Tenancies Act is commonly referred to as the RTA. The The legislation outlines that the purpose of this act is to provide protection for residential tenants from unlawful rent increases and unlawful evictions, to establish a framework of the regulation of residential rents, to balance the right and responsibilities of residential landlords and tenants, and to provide for the adjudication of disputes and/or other processes to informally resolve disputes. In other words, the RTA establishes laws for landlord and tenant obligations, rights, and responsibilities, rent regulations, such as rent increases and deposits, and provides tenants with security of tenure and outlines the grounds of termination. One of the ways the RTA protects tenants is outlining the valid reasons of when an eviction can happen. These include non-payment of rent, damages, interference with enjoyment, own use, persistent late rent, demolition, repair, or conversion. I will now pass it over to my colleague Tanya, who will be discussing the first step of eviction for non-payment of rent.
As Catherine just explained, the RTA outlines what is considered a valid reason to terminate a tenancy. Under Section 59, Sub 1, if a tenant fails to pay lawful rent owing under a tenancy agreement, the landlord may give the tenant notice of termination of tenancy. This notice is the N4 for non-payment of rent. The N4 only includes unpaid rent, also known as arrears. You do not include utilities, deduct the last month rent deposit, or add any other unpaid fees to this notice. On the screen, you will see an example of an N4 notice. When filling out the N4, it is very important to follow the instructions and to ensure that you have filled out all the information correctly. Errors on the notice can lead to a dismissal of an L1 application. When listing the names of the tenants, include the names of those identified on your tenancy agreement as tenants. Or in the case of a verbal tenancy, include the names of only those who have been paying rent. If your tenant uses nicknames, use both their legal name and their nicknames. If you have a joint tenancy, which is where there are more than 2 tenants on one agreement, make sure to include all of their names. In this case, there is 1 tenant and their name is Jane Doe. The same applies with landlords. Include the full name of all the landlords for the rental unit. In this case, the landlord is John Smith. Now for the address. It is very important for the address of the rental unit to include the full address and specify where exactly the tenant is living, such as the main floor, basement, upper floor, or the specific unit number. On this N4, the address is basement 123 Main Street, Toronto, Ontario, M1M 1M1. Now for the termination date. If the tenant pays on a monthly basis, then the N4 notice is a 14-day minimum notice that gives the tenant 3 options, which will be discussed later on. Note, when calculating the termination date, the day this notice is delivered to the tenant is considered day 0. The next day is day 1. For example, if you give the notice on the 2nd of the month, add 14 days starting the 3rd. This means the termination date will be the 16th of that month. Please be cautious of the 14-day termination date, as multiple factors may impact when the termination date is. For example, if the tenant pays on a daily or weekly basis rather than a monthly, then the termination date is 7 days. Please note that the 14-day termination date will be changed to 7 days starting September 21st, 2026, due to Bill 60. Furthermore, method of service may also impact the termination date. For example, if you mail the N4 notice to the tenant, please add an additional 5 days to the termination date. Now, if you look at the screen, the I believe you owe me box should state the total amount of arrears. Do not deduct the last month rent deposit from the total arrears owing. The amount in this box should also match the total arrears owing in the chart shown on the second page of the N4. Be very careful when filling out this table. It is important that the rental periods are listed correctly because the smallest mistake will likely mean you having to start the process all over again. For example, if rent is due on the first of the month, then the rental period would run from the first of that month until the very last day of the same month. If rent is due on the 15th of the month, the rental period would run from the 15th of one month to the 14th of the next month. If your rental period shows the 1st to the 1st or 15th to the 15th, this is incorrect, and you'll have to reserve the notice to your tenant. Under the rent charge portion, put the monthly rent owed. Under rent paid, put whatever amount the tenant has paid. If the tenant did not pay anything, write 0. Under rent owing, deduct the rent paid from the rental charged amount and put the total amount there for that specific period. Once all the rental periods are ready, add all the rent owing up to get the total rent owing. Note the total rent owing here should be the same as the first page on the N4. Now for the signature portion. If there are multiple landlords, only one of them need to sign the notice. The next date to the signature is the date the notice is given or sent to the tenant. Review the notice to make sure there are no mistakes, and that you understand what you're giving to the tenant. Keep a signed copy for yourself. Now the certificate of service. Make sure to deliver the notice to the tenant according to the landlord and tenant board rules. Improper service will result in you having to start the process all over again. The most common methods of service are delivery in person to the tenant, sliding it underneath the door of the rental unit, or putting it in the mailbox as long as a key is not required to access the mailbox. The certificate of service lists different methods of service. If you choose the mail the N4 notice, make sure to add an additional 5 days to the termination date. The landlord can also send the notice by email, but only if there is consent to serve notices by email. This can be found on the second page of the Ontario Standard Lease Agreement. The box should be checked off and the tenant's email address should be listed there. Never post the notice on the door of the unit or send it by text message, as this is improper service and will make the notice invalid. This is what the certificate of service form looks like, and this is a form that tells the landlord and tenant board who served the notice to the tenant, when the notice was served, and how it was served. When completing this form, it is important to include the exact rental unit address that was recorded on the document provided to the tenant. The name of the person who served the document should be recorded on the line next to the date the document was given. Put an X in the appropriate box, which is most often the termination form. Write the form number on the line provided. Indicate that the notice was provided to the tenant and write their name on the line. In this case, it states, I, John Smith, certify on July 11th, 2026, I gave a copy of the following documents and 4 to Jane Doe. The next part of this form deals with the way in which the document was served. Select the method of service you used. In this case, the landlord hand-delivered the notice and selected that method. The last section of the certificate of service should have the name, telephone number, and signature of the person who served the notice or document to the tenant. The N4 is avoidable notice, meaning the tenant has 14 days to correct their behavior and avoid eviction. If the tenant does correct their behavior by paying all of the arrears owing by the termination date, along with any rent that became due, then the landlord will not be able to file the L1 application with the landlord and tenant board. If the tenant does not pay their rent owing during the 14-day remedy period, then on the 15th day, the landlord can file the L1 application to seek an eviction and to get the arrears from the landlord and tenant board. Please note, if the tenant moves out on or before the termination date on the N4 notice, then the landlord cannot file the L1 application. By now, every landlord has heard of Bill 60, Fighting Delays, Building Faster Act. So let's talk about the impact and the changes it will have on the N4 and L1 process. At this time, it's important to understand that although Bill 60 has received royal assent, it is not yet enforced, but the changes will come into effect starting September 21st, 2026. This means that the regulations, the board rules, forms, and notices have not yet been updated to reflect the changes. In other words, the N4 and the L1 process use the current instructions from the Landlord and Tenant Board website. There are a few changes as per Bill 60 which will affect the non-payment process, but today we'll only cover the ones that with the most notable impacts. One of the changes with Bill 60 relates to the notice period for an N4 as per Section 59 Sub 1 of the Act. Currently, the N4 has a 14-day minimum notice period for monthly tenancies and a 7-day notice period for daily and weekly tenancies. Under Bill 60, all tenancies will move to a 7-day notice period, making the wait time to file an L1 application shorter. This is a significant change for small landlords, but again, it is not in effect, so continue to use the current timelines. Now I will pass it over to Catherine.
Thanks, Tanya. Moving on to the L1 application. Now that we've discussed how to properly complete and serve an N4, the next step, if the tenant does not pay, is to file an L1 application with the Landlord-Tenant Board. The L1 is the application you use to ask the board for two things, being an order for eviction and a payment of the rent arrears. The application can be filed as early as the day after the termination date listed on the N4. There are a few different ways you can file this application. The most common method is going online through the Tribunals Ontario portal, also known as TOP. You can also file by mail or in person at certain Service Ontario locations. If you file online, the fee is $186. If you use any other method, the fee is $201. One important thing to keep in mind is if you're filing by mail, you must include the proof of payment. If you don't, your application may be considered incomplete, which could delay the process of your file. Filing the L1 application. Once you have decided your method of filing, there are a few key documents and requirements you must have in place before submitting your L1 application. First, you will need a copy of a valid N4 notice, which was properly served on the tenant. This is critical because the L1 application is based entirely on that notice. If the N4 is invalid, was not properly served, or has been voided, your application may be dismissed. Second, you must include a certificate of service. This document confirms how and when the N4 was served. The board relies on this to determine whether proper service was completed and whether the correct termination period was given. Third, you will also need to pay the application fee, which will vary depending on your method of filing. It is also important to ensure that all information in your L1 application matches your N4, particularly names and the rental address. Any inconsistencies could lead to delays or issues at the hearing. For those interested in additional guidance, the Landlord Self-Help Center provides detailed learning modules on our website with step-by-step instructions on properly completing and filing an L1 application for both the mail or in-person option or using the portal. L1 versus L9 applications. A similar application to the L1, which is often asked about, is the L9 application. Both applications address rent arrears, but they serve different purposes and result in different outcomes. The L1 is used if you're requesting both eviction and a payment for rent arrears, while the L9 application is only used to obtain a payment order and will not be granted an eviction. In terms of risk, the L1 carries a higher risk of dismissal as it depends on a valid N4. The L9 has a lower risk since no notice or N4 is required. In some cases where an N4 is found to be invalid, the board may still issue you an order for arrears, but eviction will not be an option. The hearing focuses on the two applications are different. The L1 hearing focuses on both the rent owed and eviction, while the L9 focuses only on the arrears owed. The outcomes also differ. An L1 may result in an eviction order, a payment order, a conditional order, or dismissal. An L9 will typically result in a payment plan only. Finally, in terms of enforcement, an L1 may be enforced through the sheriff for eviction along with the collection of arrears, while an L9 order is enforced solely for the collection of arrears. The distinction is important when deciding which application is more appropriate for your situation. So moving on, we'll talk about when to use an L9. There are situations where an L9 may be the more appropriate option. For example, a landlord and a tenant have entered into an agreement to end the tenancy and signed an N11, but the tenant owes rent. Or if the tenant sends a notice to terminate the tenancy with 20 days, which would be considered improper notice. However, the tenant has already started moving out their belongings, but the landlord wants compensation for the full notice period. In this situation, the landlord only needs a payment to the landlord only needs to secure a payment order. In these situations, pursuing eviction is not necessary, so the L9 allows the landlord to focus only on recovering the arrears. It is important to remember that the L9 must be filed while the tenant is still in the unit. If the tenant has already moved out, the appropriate application would be an L10.
What to do before the hearing. For the L1 hearing, the focus of the hearing is specifically on non-payment of rent. The adjudicator is looking at one main issue. Has rent been lawfully charged and has it been paid? Because of that, only documents that directly relate to rent arrears and the landlord's claim should be uploaded, such as a lease agreement, an N1 or N2 if a rent increase was given, emails or text messages relating to non-payment or a payment plan, and the L1-L9 information update form. A common mistake landlords make is uploading evidence that speak to every issue they have had with the tenant. This often creates confusion and wastes hearing time. For example, the landlord should not upload photos of damages, complaints about cleanliness, or pictures of the property condition unless there's a separate application such as an N5 or an N7 attached to the matter. Similarly, photos related to illegal acts, police involvement, or misconduct should not be uploaded for an L1 hearing unless those issues are directly connected to a separate application before the board and is heard together. Do not upload long chains of text messages that have nothing to do with rent payments. Personal arguments, disputes about behavior, or unrelated complaints are not helpful in a non-payment application. Before your matter reaches a hearing, there is an opportunity to resolve the issue through a payment agreement. A payment agreement is a voluntary arrangement between the landlord and tenant to address their rent arrears, usually by settling out a repayment plan over time. The Landlord and Tenant Board provides a standard payment form, which may be used for both an L1 and an L9 application. The process can be initiated by either the landlord or the tenant. Effective July 1st, 2026, the payment agreement must be in the form that the board approves of and must be signed by both the landlord and tenant. This payment agreement can include rent arrears up to the current period, NSF and administrative charges, the LTB filing fee, and for L1 applications, it can also include future rent and Section 78, which will be discussed later on. A payment agreement cannot include an agreement to end the tenancy or evict a tenant, or non-payment of non-rent arrears such as utilities. At least 7 days before your hearing, you are required to complete an L1-L9 information update form and file it with the board and provide a copy to the tenant. This document updates the board on the current amount of arrears, any payments made since filing, any changes to the tenancy, the rental deposit amount, and more. Always ensure your calculations are accurate and up to date. On the screen, you are looking at what the L1-L9 information update form looks like. You will first need to fill out the names of the landlords and the tenants, the file number, which is found on your notice of hearing. You must also identify the rental unit. When completing the document, try to ensure the information is consistent with what you had on your L1 application and N4 notice. You must complete all 10 sections of the form and provide a current and accurate information. This form requires information post-filing the L1 application. Section 1 of the form. Has the tenant moved out of the unit? If the tenant has moved out, check yes and put the date when the tenant vacated. If they have not, then check no. Section 2. Has the monthly rent charged to the tenant changed from what was shown on the application? If the rent is the same, then check no. But if it has either increased or decreased, then put the new monthly amount and the date the change became effective. Section 3. Has the rent deposit changed, or have you paid interest on the rent deposit? If you have not paid interest on the deposit, and if you have no deposit, then check no. If you have, then check yes and put the current amount held on and report the period for which interest was paid. If you do not have a last month rent deposit, then check no and leave the section blank. Section 4. After you filed the application, did you receive any additional payments? If you have received any payments from the tenant towards the rent, then check yes. If you have not, then check no. Be sure to record the amount you received and on what date you received each payment. Now let's move on to Section 5 of the form. This is where we will record if any new rent has become due since filing the application. You will make a note of the rent amount that became due and on what date. In this example, 3 rental periods have passed since filing the L1 application: February 1st, 2026, March 1st, 2026, and April 1st, 2026. The monthly rent is $1,700. Section 6. This is where you will list the total amount of rent the tenant owes you. This includes the total of rent arrears. Do not subtract the last month's rent deposit and do not include the application fee or any NSF charges here. Section 7. In addition to the rent owed, if the tenant was paying Viva check and you were charged an NSF or incurred administrative fees, this is where you will add it. You will mention the amount that was payable per the check, the date that on the check, and the date you received the NSF. You will then state the amount the NSF and administrative charge. Section 8 allows you to ask for reimbursements if you have the filing fee. The amount you will be claiming here is dependent on how you filed the application. For example, if you filed the application on top, then you will select 186. But if you filed the application at Service Ontario, you will select 201. Section 9 is where you will add all charges. This includes arrears, NSF fees, and the filing fee. Do not deduct the last month's rent deposit from the outstanding when calculating the grand total. The board will do this for you. During the L1 hearing before the board will consider conditions that could result in a delay or refusal of an eviction. This is covered in Section 10. It is also referred to as Section 83 issues, which will be discussed later on. What you see on this slide is a continuation of Section 10. If you select yes, then you will detail the circumstances you are aware of. It is important to note that even if you leave the section blank, the tenants could possibly raise the issue and it will be considered. Once you have completed the form, you will then sign and date the document and provide it to the board and to the tenant 7 days before the hearing. If you will be relying on other evidence, you will also submit it at this time as well. The Landlord Self-Help Center does provide a short but detailed learning video on completing the L1-L9 information update form. Please feel free to visit our website and explore our learning module for more. This slide uses a chart to illustrate what your day will look like once you log into your hearing. For the L1 hearings, you'll be heard in a hearing block. This means you'll be one of many parties there to have their matter heard. When you log into the hearing room using the video link or by phone number provided on your notice of hearing, you will be directed to a general room. Please ensure you keep yourself on mute until you are spoken to by the moderator. Once the moderator calls you by your screen name or phone number, you will be expected to identify yourself by providing your file number, your name, and your relationship to the file. In this example, it would be John Smith, file number LTB-L-02000-26, and I am the landlord. Once you have identified yourself and your file is located, you will then be issued a docket number. Your docket number does not indicate when your matter will be heard. The board tends to prioritize uncontested and consent matters before contested ones. So if your matter is contested, it will take a little bit longer. Now that you have been identified and you have a docket number, you will be asked if you are interested in mediation or not. If both parties are agreeable to mediation, you will be sent to a private room with a dispute resolution officer, also known as a mediator or DRO, who can help both parties in coming to an agreement. The DRO is also able to issue consent orders. If an agreement is reached, it is important to ask for Section 78 as one of the terms and to ask that it be clearly written in the order. Section 78 will be discussed later on in the presentation. If both parties are unable to reach an agreement, then you will be sent back to the hearing room where the adjudicator will hear your matter as a contested matter and will make a decision. The decision or order will be sent out later on. Now I'll pass it back to Catherine.
Thanks, Tanya. For the remainder of the presentation, I'm going to discuss certain sections of the Residential Tenancies Act that have an impact on an L1 hearing. The first being Section 80. Essentially, a tenant is allowed to seek offsets when the eviction is based on non-payment of rent for any reason that could provide a monetary remedy under any tenant application. A tenant does have to provide notice to the landlord if they intend to bring up Section 82 issue 7 days prior to the hearing. The limitation period of 1 year applies, meaning if the tenant is trying to claim compensation for an issue that was resolved over 1 year ago, it should not be allowed. Now, there is a general understanding that a tenant is not allowed to withhold rent, for which the most part is true. However, Section 82 claims can be successful. For an example, the tenant would likely receive an offset to their arrears if a landlord illegally increased the rent and continued to pay the rent amount prior to the illegal increase, and the landlord pursued an L1 application for the amount of arrears accumulated based on the illegal increase. Another example could be if the landlord failed to comply with their maintenance obligations. Let's say the fridge in the unit broke down and the tenants paid out of pocket to replace the fridge. The next month, they remitted rent payment for the rental amount less the cost of the fridge, and the landlord pursued a non-payment of rent application. It would likely be found that the offset for the fridge is something the tenant would be successful in claiming. Now, Bill 60 and the impact on Section 82. Bill 60 will also be implementing changes to this section of the Act, although a date has not yet been set for when landlords can expect these changes. Currently, the board and adjudicators have a lot of discretion to allow a tenant to bring up issues, even if the notice requirement was not strictly met. Under Bill 60, tenants will be required to give advance notice in writing with strict timelines and must pay at least 50% of arrears to be able to exercise their right under Section 82. The payment of the 50% must be made before the hearing date and in accordance with any prescribed timelines. We are hoping that the provincial government confirms the date for these changes soon, as this would significantly limit last-minute tenant claims and create a more structured process. Section 83. Section 83 gives power to the board to delay or deny an eviction. There are certain circumstances where the board must deny the eviction, which include a landlord is in serious breach of the landlord's responsibilities under the Act or any material covenant of a tenancy agreement. The reason for the application being brought is that the tenant has complained to a government authority of the landlord's violation of a law dealing with health, safety, housing, or maintenance standards. The reason for the application being brought is that the tenant has attempted to secure or enforce his or her legal rights. The reason for the application being brought is that the tenant is a member of a tenants association or attempting to organize an association. Or the reason for the application being brought is that the rental unit is occupied by children and the occupation by the children does not constitute as overcrowding. The board, however, can delay an eviction for any reason if the adjudicator feels that there's prejudice to the tenant. These type of reasons may include if the tenant has been there for a very long time, if there are children who reside in the unit, if the tenant is temporarily unemployed. Although Section 83 does not outline a prescribed time to delay an eviction, what we usually see in practice is that the eviction order be pushed back to 60 days notice versus the standard order of 11-day notice. Landlords should also be cautious that the board shall take into consideration whether the landlord has attempted to negotiate an agreement or payment plan with the tenant prior to deciding if they are going to grant a delay or denial of eviction. Bill 60 and the impact on Section 83. Bill 60 will also implement changes to Section 83, which again, a date for when we can expect these changes has not yet been set. Right now, the landlord-tenant board adjudicators have complete discretion when deciding how to apply Section 83, such as what factors are significant enough to deny or delay an eviction, and how long the eviction delay can take. These changes will make their decision to delay eviction subject to prescribed limitations or conditions, meaning there will be an outline as to how long delays can happen and for what reasons delays can happen. At this time, we do not know what those prescribed limitations or conditions will be. Lastly, Section 78. Section 78 is a clause that could be a part of your non-payment of rent order. You will most often see this type of clause if you or your tenant come to a mutual agreement during mediation, or if the adjudicator decided that the tenant is able to remedy the situation and avoid eviction. In the case of an L1 and N4 non-payment of rent application, the Section 78 would be something like a payment plan towards arrears. For example, the tenant would be ordered to pay the rent on time plus $1,000 each month towards their arrears. That section of the order would be subject to Section 78, meaning if the tenant fails to comply with the payment schedule, the landlord can apply to the board with an L4 application. An L4 application would grant an eviction order without having to go back for a hearing. All right, that concludes the presentation part of our Lunch and Learn. As a reminder, Landlord Self-Help Center has a number of resources available on our website, such as our Residential Tenancies Act fact sheets, sound advice podcast, landlord learning modules, and our landlord learning videos. We also have our social media channels, which include Facebook, YouTube, and Instagram. I'll pass it over to Diana now, who is going to lead the question and answer period.
Thank you so much, Catherine and Tanya, for the presentation. So now we're going to go over the questions in the chat and the Q&A. If people have questions, could you please share your questions on the Q&A option? So I'll just read the chat first. Do landlords have to offer a payment plan option to help tenants pay rent if they express they are not able to pay the rent before filing for non-payment of rent? Catherine, could you please answer that question?
Yeah, so when I was discussing Section 83, that part of the legislation was actually on one of the slides. It says a landlord shall take into consideration if an attempt or negotiation has happened. My advice, in practicality, but also because of what the legislation says, is the landlord should always try to work out some sort of payment plan with the tenant. You're more likely going to receive a unilaterally imposed payment plan if you haven't already tried to get one with your tenant. So I hope that answers the question.
Thank you. And please remember that all the questions will be limited to the N4 and the process. So any other questions unrelated will not be answered, and we will ask you to please call our office or reach out to us in order to get an answer. For the Q&A section, let me open it. Okay, so someone is asking, so I have a tenant that is due to be evicted in 2 months' time. I'm assuming it is based on N4 and an N4 notice. If she has stopped paying rent, if I serve an N4 and get the judgment, which the landlord thinks they will, um, I don't think I can collect as a tenant is on ODSP. But she doesn't have any other assets. What can the landlord do to limit the loss? Tanya, would you like to answer that?
Yep. So if you do get an eviction order based on arrears and the tenant is on ODSP, It is very difficult to get the money back. Um, Unfortunately, you always do have the right of going through small claims court, but we advise people that if the tenant is on some sort of social assistance, we primarily tell people to focus more so on getting the actual eviction and filing with the sheriff compared to actually trying to get the money owing.
Thank you. If the landlord doesn't want to attend mediation, will that hinder their case? Catherine, can you answer that, please?
Again, it's kind of similar to the last question we got asked. You know, at the end of the day, the RTA is there to protect tenants and the board is there to enforce the RTA. So whenever there's a viable reason to keep a tenancy intact, the board is likely to do that. So same with, trying to offer a payment plan, same with mediation. It's going to be favorable for you to try to work with your tenant to agree to a payment plan because the board does ultimately have the power to impose one that may, be a longer period than you're expecting to get money back or shorter, smaller, amounts monthly that you would want to see come back. So no, it's not an obligation, but it's highly recommended.
Thank you. If I added the guarantor on the N4, would it be considered void? At what point is the guarantor advised action taken against them? Tanya, can you answer that, please?
It depends on the adjudicator. It's always better to, even if it was a tenant that you weren't sure was the tenant or not, it's always better to include their names than to not. If anything, it'll go to a hearing and then the adjudicator would remove that person's name. But say hypothetically, the person's name wasn't even on the notice to begin with, that would make it voidable. But as a whole, you should never include a guarantor's name on the N4 because they're not a tenant.
Okay, thank you. If there is more than one landlord listed on the lease agreement, do we need to ensure that additional landlords also sign the various LTB forms? Is it sufficient to just have one landlord sign all notices and forms? Catherine, can you answer that, please?
Yeah, if you look at the N4, the certificate of service, the L1, the L1, L9, it only has a spot for one signature, so it is fine for only one landlord to sign. Often at the hearing, if multiple landlords show up, they expect only one person to speak anyways. Uh, if you have more in-depth question about that, maybe it's something you could call the office about.
Okay. Somebody has a question about witnesses. We didn't really talk about witnesses during the N4 process, but do you, Tanya, do you see any use of witnesses in an N4 process?
With an N4, it's really not necessary unless there's a doubt on when a tenancy began. Maybe then it will be useful to have a witness. But most of the time, from my experience, and witnesses are usually used for like an N5 or an N7, not for arrears. Arrears are relatively straightforward. You just explain how much the tenant owes, um, and then how you got to that calculation.
Yeah, so maybe for this viewer asking questions about the witnesses, you can give us a call and we'll be happy to talk to you about the witnesses role. Um, yeah, so any unrelated questions, please call us. How many N4s are needed to be able to give an N8? Yeah, so this was not discussed during the presentation, so please call. Do I need a new lease if I have one tenant paying one rate for a bedroom and two tenants paying another rate for a shared bedroom in a basement apartment? Will I have to do a new lease for each bedroom? So that's more, yeah, unrelated question. So once again, please call us. Um, Somebody was asking about, yeah, if there's more than one landlord yeah, listed on the lease agreement. That was already answered. Okay, so what if rent payment is by check? Unfortunately, it takes time for checks to clear the bank. I believe it can take up to 5 days. I won't know if the rent check bounced until it clears the bank. Catherine, I think it's your turn, right?
Yeah. So as soon as you find out that the check bounced, you would be within your right to start the N4 process. There's also remedies to landlords when it comes to the L1 to include the NSF fees. But you would, yeah, unfortunately, if you're accepting check as your method of payment, you can't just start the N4 process because of the wait time that it takes for the check to clear.
Thank you. Somebody's asking, if we have already given N4s and plan to give an N12 in good faith, are we able to take arrears out of the 1 month compensation that is given along with the 60-day notice, as long as the arrears have been properly documented and the tenant has been emailed as to why their compensation is what it is the day prior to the termination date? Or would we have to take the N4, give the full compensation, and proceed with an L9, which seems to be redundant? So yeah, we did not discuss N12s. But yeah, please give us a call to discuss this scenario. Where non-payment exceeds 3 months, how are additional non-payments recorded on the N4? Tanya, would you like to answer that?
Yeah. So as you guys saw, the N4 notice, it does have only three slots to include the rental periods or the arrears. What you do is you would have to write C attached on the chart and then copy that same format on a Word document, and then you can fill it out one by one. If you want more details, again, you can always call us and we can go into more details about what you should do.
Okay, so landlord and tenant agreed on a payment plan. The tenant did not follow through. Can the landlord successfully refuse to discuss a payment plan during the hearing? Catherine, can you answer that, please?
Yeah, I always advise people if you are, at the L1 hearing and your tenant has already been offered a payment plan that they have not kept up with, to bring it up in, what's kind of meant to be like your closing argument. Ultimately, it's going to be up to the adjudicator what they do with that information. But it is relevant to your case if there was a payment plan that you entered into and the tenant was unable to upkeep their end of the bargain. So it's certainly worth mentioning, and I think it would work in your favor if ultimately you're seeking as an eviction.
Thank you. So can we give N for the first time the tenant is late? Tanya, can you answer that, please?
So if the tenant owes money, so for example, if it's due on the first, and it's say it's May 2nd, rent hasn't come through, then at that point you can issue an N4 notice. As mentioned in the slides, it is a remediable notice. So they have 14 days to pay the amount owing. If they don't pay it, then you can always file the L1 after the termination date.
Even if it's the first time. Yeah.
Yes.
A payment plan offer in the past due to persistent late payment, tenant is starting to pay late again with no notices and forgiven and the tenant paid on the last day of the N4. I think that was more of a comment, not a question. Is there a list of outstanding work orders where a tenant has a right to pay their full rent because of outstanding work orders that need to be fixed? We didn't really discuss work orders. So yeah, please call us in order to get an answer to that question. Um, okay, so if the tenant pays rent by cash, can I stay the time when I will be collecting rent, or the tenant can come anytime to my place and bring the rent? I am also tenant in the house. Okay, so we'll answer based on the landlord's perspective, but Tanya, can you answer that, please?
Yep. So the requirement is, as a landlord, you can collect whatever method of payment you like. So if it's cash, but you should communicate with the tenant on when you would like to collect it by. But if the tenants want to pay, say at 9 in the morning or 8 at night, they have a right to do so. You can't put a strict deadline on when you can accept that payment for that day.
Okay, can you request e-transfers for rent payments? Catherine?
Yeah, the only method that a landlord can't force a tenant to pay is post-dated checks, but you can stipulate in the lease that the accepted method of payment is e-transfer.
Perfect. So somebody has a question about the L4. Unfortunately, we're not going to be able to answer that at this time, but please contact us. Um, so yeah. Refer to section 83. If the tenant lived for a long time and lost their job, does the landlord have to work out a payment plan before filing L1? Tanya, can you answer that?
Yep. As mentioned before, it's always best to try to work out a payment plan. At the end of the day, if it does go to a hearing, the tenant has the right to bring up these issues. The adjudicator will consider it in their decision whether they'll issue a payment plan or go forward with one the eviction should be.
So how about if I'm not there to collect the rent in cash? The tenant pays via e-transfer and sometimes by cash. Catherine?
Um, I mean, I always encourage landlords to be, if the reason why your tenant didn't pay you on time was because you didn't make yourself available, that's not a valid reason to give an N4. Also keep in mind because of being the void period, you could just be forcing yourself to do paperwork that's unnecessary. Because let's say the tenant goes, it's the first, I want to meet you at 5 o'clock, and you say, no, I'm out for dinner. You have to be here at 3. Then, you give them an N4, they show up tomorrow with the rent, they voided the N4. Um, I wouldn't recommend accepting cash as rent payment, just because of these, things. You have to be there to physically accept it. But I hope that answered your question.
Okay, I filed an N4 on March 4th for unpaid rent from December, January, and February only. The due rent is it's due on the first of each month. I did not include much rent because I intended to use the tenant's last month's rent for the final months of the lease. March 2026, I later filed an L1. Now I was told the N4 may be incorrect because March rent was not included. My hearing is in late May. Would this make my application defective or dismissed? Can this be corrected through amendment, the L1 or an L9 application? Tanya, can you answer that, please?
Yep, you should never deduct the last month rent deposit. One of the main reasons is the adjudicators will deal with that. Also, depending on how long the tenant stays there that also might impact what interest the tenant is entitled to. Um, if there is an error on the N4 notice, it is defective. Um, it may be best to just start the process all over again and issue a new N4. Um, Before the hearing, there is an information update form. So you can include any arrears owing on that form, but it should really only include what was missing or what was incurred after filing the L1, not beforehand. So it's best to serve a new N4 notice.
Okay, so this is a follow-up to the rent payments, cash or e-transfer. Somebody said I would not like to accept cash, but the tenant has a right to pay by cash, right? Catherine, I think you're the one answering the question.
Um, so yeah, I mean, you can stipulate in the lease agreement how rent is to be paid. The problem with that is if you deny any rent payment and you get yourself in front of an adjudicator at an L1, you're not going to be granted the eviction. So put in writing to them that you won't accept cash, but ultimately you're better off to take the money any way that they're going to pay it.
Thank you. Somebody's asking how many N4s can be voided before it's considered persistently late and can evict. So this is not part of the N4 presentation. But do you have any recommendation, Tanya, in general terms about that?
Um, Generally speaking, we say persistent late should be 6 to 7 months consistently. Um, Whether you give an N4 notice for each time, it's up to you. but you don't necessarily need to give an N4 each time the tenant is late on rent.
Yeah, but I think it would be best just to keep everything clear and consistent to give the N4 every time the tenant is late, even if they void the N4.
I
So
just
if,
want to, oh,
sorry,
sorry, I
go
just want
ahead.
to add into that too. That's one of the things that's meant to happen with Bill 60 is they're meant to put in regulations to actually define persistent late rent. So, similar to some of the topics I talked about under the changes that are happening to Section 82 and Section 83, that's one of the ones that we don't have a date yet for. But it's something for all landlords I encourage to, continue monitoring, paying attention to. We're also, um, we're also taking the big endeavor is to make sure as soon as we have the information, we're sharing it across our social media channels and everything else too.
Thank you. If the L1 hearing date is June 2nd and rent is due on June 1st, when I update the L1 update form 7 days before the hearing, May 23, can I include the rent due for June? Catherine, can you answer that, please?
Um, I know that's always a question. First of all, it's 5 days that you have to submit the L1, L9. Um, because adjudicators have a lot of discretion as to what they accept, what they consider late, I always recommend to do one to comply with the 5 day notice and to submit a second one with the updated amount as soon as June's rent is not paid.
Thank you. No lease or contract in place, tenant of 20 years pays with check. Can I ask for e-transfer payments now? Tanya, can you answer that?
You can always ask the tenant to provide payment through e-transfer, but it's really up to them. If they choose to pay by check, unfortunately, you can't deny accepting the check. You would have to.
Thank you. And just if somebody wants to confirm, you do not include last month's rent in any amount owing. Catherine, can you answer that?
No, last month's rent should never be included or deducted from arrears.
Or applied or anything? Um, okay, so I have a house and the basement has been rented out to a tenant by my former husband, who I am in the process of divorce. There is no lease agreement, and the tenant is paying the rent to my former husband. I had no idea and no consent for renting the basement. Can I serve an N4 based on non-payment of the rent and ask for eviction of this illegal tenant in my illegal basement? We're not living there, and my ex has the key to that place. So this is a question about who the landlord is. Tanya, can you answer that?
Yeah. Unfortunately, if the tenant is paying the other individual who's acting as the landlord or is the landlord, um, you as the second landlord, you wouldn't be able to issue an N4 notice because technically speaking, the tenant is paying or making payments to the landlord. So it's not considered non-payment. If you want to discuss more in detail about your specific situation, you can always give us a call.
Yeah, because this would be a distinction between who the owner of the property is versus who the landlord is. So
Yeah.
yeah, I think it would be better if the person calls our office for more information. And we're just going to see, double check that we've answered everyone's questions. Once again, for any question that we did not answer today, most likely was not related to the presentation, but please call back and we can help you over the phone. Just going to quickly share the last. Um, so yeah, that would be it for the Q&A answer period. Um, we have some upcoming Landlord Launch and Learn series webinars on October 14th. That would be ending a tenancy and all the ways that a landlord can lawfully end a tenancy. And we're already gearing up for next year on February 17th for maintenance obligations. Keep an eye out on email communication from us, and you can learn how to register for the upcoming webinars. And of course, our survey for today's presentation, it will help us improve our future webinars and just, to know how we did today. So thank you so much to everyone for attending today's presentation. As Catherine said at the beginning of the presentation, the recording will be available together with the presentation slides by Friday, and we will email all our subscribers to let them know that the recording and slides are available as well. We'll make a post on our social media accounts to let everyone know as well that these are available. So if you don't follow us on social media, start doing it so you can get the latest information about it. Um, so that would be it. Thank you so much. And Catherine, Tanya, thanks.